If
The
we move
letter
the access
arrived on a
road
quiet
here, we
Tuesday
avoid the
morning,
wetlands entirely.
folded neatly,
That aligns
like
with the
it carried
forestry
good
report
news.
data.
It
Make a
didn't.
note of that.
Inside was a single
Your
sentence
Honor,
that made my
these
hands
documents clearly
freeze
demonstrate the
midair.
defendant's
You are
negligence in this
illegally
matter.
occupying public
you,
land
Counselor.
and
The
must
court accepts
vacate
this
within
evidence.
30 days. Public land. I read it again and again. My name was correct. My address was correct. The logo at the top belonged to the neighborhood HOA. But the claim felt absurd, like being told the sky had been sold overnight and I now owed rent to breathe. This was the same land my family had owned for years. The same patch of soil where my father planted mango trees with his bare hands. The same backyard where birthdays, late-night barbecues, and quiet morning coffees had slowly stitched themselves into memories. Suddenly, a group of strangers in pressed shirts and clipboards were saying it never truly belonged to us. At first, I thought it was a mistake. HOAs send warnings all the time about grass height, paint colors, fences. Maybe someone clicked the wrong file. Maybe it was meant for another house down the street. So I did what any reasonable person would do. I called them. The voice on the phone was calm, almost rehearsed. According to their records, the strip of land behind my house had been designated as community property, a public access zone, a shared recreational space. And because of that, I had been using it without authorization. I remember stepping outside after that call and staring at the yard like it had betrayed me. The trees hadn't moved. The fence still stood exactly where it had been for years. The swing set creaked softly in the breeze like it always did. Nothing had changed, except suddenly everything had. That night, sleep didn't come easily. Questions kept stacking up like unpaid bills. How could land that existed in my property documents suddenly become public? Why now? Who decided this? And the biggest question of all, what happens if I don't leave? 2 weeks later, the answer showed up in the form of construction stakes hammered into the ground behind my fence. Bright orange ribbons fluttered like warning flags. A small sign read, "Future site of community walking trail." They weren't just claiming the land. They were already planning to build on it. That was the moment the confusion turned into something sharper, something heavier, something that felt a lot like a fight had just begun. And what the HOA didn't realize yet was that I had just opened my property documents. The folder was thicker than I remembered. It had been sitting in a drawer for years, buried under old warranties and faded instruction manuals. The kind of paperwork you assume you'll never need again once the house keys are in your hand. But that night, every page suddenly felt like it held the answer to a question I didn't even know I'd be forced to ask. Property deed, survey map, purchase agreement, county stamps, signatures, dates, everything official, everything very real. And right there, in black ink and perfectly straight lines, was the boundary of my land, stretching clearly beyond the fence, all the way to the row of mango trees. I stared at the map, so long the lines started to blur. Either this document was wrong, or the HOA was. The next morning, I walked outside before sunrise. The air was quiet and cool, the kind of silence that usually feels peaceful. But now it felt tense, like the world was holding its breath. The orange construction ribbons still danced in the wind, tied to wooden stakes planted confidently in soil that, according to my paperwork, wasn't theirs to touch. It felt strange standing in your own backyard and suddenly wondering if someone might tell you to leave. I started asking neighbors, carefully at first, casually, like it was just a small misunderstanding. Did you hear they're building a walking trail? Most people nodded. Some were excited. A few were confused. But then one older neighbor lowered his voice and said something that made my stomach tighten. They've been talking about that trail for years. Years. Apparently, the HOA had wanted a shared walking path connecting the far end of the neighborhood to the small park near the entrance. It was supposed to increase property value, improve community appeal, make the neighborhood more walkable. At least, that's how the newsletters described it. But there was one problem. The proposed path ran directly behind my house. And according to the HOA's version of reality, that land had always been part of a future public easement, a strip reserved for community use, something buried in old neighborhood planning documents most homeowners had never seen. Most homeowners, not the one whose backyard it ran through. The more I dug, the stranger got. Old HOA meeting notes mentioned the trail as a long-term vision, a pending project, a future development opportunity. Words that sounded harmless until they were no longer theoretical, because now there were stakes in the ground. Now, there was a deadline in my mailbox. Now there was a clock ticking. I emailed the HOA asking for proof. Not opinions, not summaries. Actual documentation showing that the land had ever been designated as public or shared property. Their reply came 2 days later. Short, formal, polite. They attached a single page from a decades-old neighborhood development plan. A photocopy, slightly crooked, with a faded diagram and a thin dotted line running behind several homes, including mine. Next to it were the words, "Proposed Community Access Corridor." Proposed. That word stuck with me. Proposed didn't mean approved. It didn't mean recorded. It didn't mean legally transferred. At least, not in any way I understood. But the HOA's email ended with a sentence that felt like a quiet warning. "We expect your full cooperation moving forward." Cooperation. The kind of word that sounds friendly until you realize it isn't optional. That evening, I stood at the fence again, watching the sunset bleed through the trees. I tried to imagine strangers walking past my backyard every morning. Joggers, dog walkers, strollers, conversations drifting through the air where silence used to live. And for the first time, the fear changed shape. This wasn't just about land anymore. It was about being told something you know is yours suddenly isn't. And the deeper I looked into the documents, the more one question refused to leave my mind. What if they were counting on me not fighting back? The next few days felt like living in two different realities at once. In one world, life looked normal. People watered lawns. Kids rode bikes. Delivery trucks came and went. But in the other world, the one quietly unfolding behind emails and documents, it felt like invisible lines were being redrawn around my life. And the worst part, most of the neighborhood didn't see a problem. When the HOA announced the walking trail officially in their monthly update, the reactions were overwhelmingly positive. Words like exciting, beautiful, and great for property values filled the community chat. Someone even posted a mock-up of smiling families strolling along a tree-lined path. The path ran exactly where my mango tree stood. I read the comments longer than I should have. Every thumbs up felt personal, even though I knew it wasn't meant to be. No one was saying my name. No one was pointing at my house. To them, this was just a community improvement. To me, it felt like a countdown. That's when the second letter arrived. This one was thicker, heavier. The tone had changed. It mentioned non-compliance, community bylaws, and the possibility of further action if I interfered with the development timeline. They even included a suggested date for fence removal to avoid delays. Fence removal. I remember sitting at the kitchen table, staring at that phrase while my coffee went cold. It's strange how a few words can make a home suddenly feel fragile. Like something permanent had quietly become temporary. For the first time, doubt crept in. What if I was wrong? What if somewhere buried in legal language and decades-old paperwork, there really was a clause I missed? What if fighting this turned into a long, exhausting battle I couldn't afford? That night, I opened the HOA documents again. Every page felt heavier than before. Legal phrases twisted into knots. Sentences stretched longer than they needed to be. It felt like trying to read a foreign language you almost understood. And that's when I found the first crack. Buried deep in the bylaws was a section about future community improvements. It mentioned proposed easements, potential expansions, and long-term planning goals. But the language kept repeating one word: approval. Board approval, city approval, homeowner notification, recorded amendments, steps, processes, signatures, not suggestions, requirements. If the walking trail had truly been approved years ago, there should have been a paper trail as solid as the one sitting in my drawer. Clear records, filed updates, something official that transformed a dotted line into reality. But so far, all I had seen was a photocopy of a proposal. Still, the HOA kept acting like the decision had already been made. Meanwhile, the neighborhood buzz grew louder. Surveyors began visiting nearby properties. Not mine, not yet, but close enough that I could see them measuring distances and taking notes. Watching them work felt surreal, like seeing strangers plan a party in your backyard without inviting you. Then came the conversation I wasn't expecting. It happened while I was taking out the trash. My neighbor from 2 houses down walked over slowly, hands tucked into his pockets like he wasn't sure he should be there. "I heard you're pushing back on the trail." His tone wasn't angry, just cautious, curious. I nodded. He looked toward the trees, then back at me. "I get why," he said quietly. "But you know, a lot of people really want this." There it was, the first glimpse of the real pressure building beneath the surface. This wasn't just me versus the HOA. This was me versus expectations, versus convenience, versus the idea that one person shouldn't stand in the way of something that benefits everyone else. And for a moment, guilt crept in. What if I was the obstacle, the difficult neighbor, the reason a project stalled, the story people told about someone who couldn't compromise? But the guilt didn't last long, because later that evening, I noticed something new behind the fence. A small spray-painted mark on one of the mango trees. Bright, neon, impossible to miss. An X. I walked closer, hoping it meant something harmless. A survey mark. A measurement point. Anything ordinary. But deep down, I already knew what it meant. Someone had started deciding which trees would go. That night, the house felt different. Quieter. Heavier. Like it was waiting for something. I sat at the table with the letters spread out in front of me, the property map beside them, and the HOA email glowing on my laptop screen. The words "full cooperation" echoed in my mind, louder than before. And for the first time, a new thought surfaced, one I hadn't allowed myself to consider yet. What if this didn't stop at the fence? What if the trail was only the beginning? The surveyors showed up 3 days later. No warning. No email, just a white truck parked across the street, and 2 men unloading equipment like they'd done this 1,000 times before. Tripods, measuring wheels, bright vests, clipboards. They walked straight toward the fence. My fence. I stepped outside before I even realized I decided to. The morning air felt sharp, the kind that makes every sound carry farther than usual. Gravel crunched under my shoes as I crossed the driveway. "Can I help you?" I asked. One of them looked up politely, the way you look at someone who isn't part of the job, but isn't exactly in the way either. "We're here for the trail measurements." The way he said the trail made it sound permanent, like it already existed somewhere, and they were just catching the real world up to it. I told them the land was under dispute, that the HOA had no legal approval, that they needed to stop. They exchanged a glance, quick, silent, the kind people share when they don't want to get involved in the drama behind the instructions they've been given. "You'll have to take that up with the HOA," the other one said gently. And then they kept measuring. It's a strange feeling, watching someone treat your property like a project site, like the outcome has already been decided somewhere far away from where you're standing. That afternoon, I sent another email. This one wasn't casual. It wasn't curious. It was direct. I attached scans of my property deed, the survey map, and a formal request for proof of the recorded easement they kept referencing. Their response came faster this time. Too fast. "We are moving forward according to community development plans. Delays may result in legal action." Legal action. The word sat heavy in my inbox, like a door slamming somewhere I couldn't see. For the first time, the conflict felt official. Real. Not just letters and meetings and polite phrases. This was moving toward something bigger. Something that didn't end with emails. That evening, the neighborhood group chat exploded. Someone had posted a photo of the surveyors working behind my house. The caption read, "Trail progress starting." So exciting. The comments flooded in. Clapping emojis. Celebration messages. Questions about completion dates. No one mentioned me. No one asked whose yard it was. No one wondered if there might be another side to the story. And maybe that was the hardest part. Being invisible inside your own problem. Another message popped up later that night. Private this time. From a neighbor I barely spoke to. "Is it true you're threatening to sue the HOA?" I stared at the screen longer than I should have. Threatening. The word felt twisted, like the story had quietly flipped while I wasn't looking. I typed. Deleted. Typed again. Closed the app. There's a moment in every conflict where you realize the narrative has started moving without you. where people have already chosen sides based on half-heard details and friendly newsletters. And suddenly, you're not just defending your land, you're defending your reputation. The next morning, the stakes rose again. A bright yellow notice was taped to my front door. Not mailed, not emailed, taped. The bold header read, "Notice of Noncompliance." It listed violations, deadlines, possible penalties. It mentioned daily fines if construction was delayed. It referenced bylaws, sections, enforcement procedures. Paragraph after paragraph of official language designed to sound final. At the bottom, in smaller text, was a line that made my chest tighten. Failure to comply may result in legal proceedings. There was again, legal proceedings. I stood on the porch holding the notice while the neighborhood slowly woke up around me. Garage doors opened. Engine started. Morning routines carried on like nothing had changed. But everything had, because now the fight had a countdown attached to it. That afternoon, I made the call I'd been avoiding. A real estate attorney answered on the third ring. Calm voice, measured tone, the kind of voice that sounds like it lives in rooms full of documents and quiet decisions. I explained everything. The letters, the surveyors, the proposed easement, the fines. There was a pause on the line when I finished. A long one. Then he asked a single question. "Do you have your original deed and survey in front of you right now?" I said yes. "Good," he replied. "Because if what you're telling me is accurate, this shouldn't be happening." My grip tightened around the phone. He continued, slower this time. "We need to look at this immediately." And for the first time, the situation shifted from overwhelming to dangerous. Because the HOA wasn't just planning a trail anymore. They were already acting like the case was closed. And the attorney had just told me it hadn't even begun. The attorney asked me to email every document I had. Every page, every letter, every email, every photo of the survey stakes, and the spray-painted X on the trees. I stayed up late scanning paperwork, naming files, double-checking dates. By midnight, my laptop screen was glowing with folders labeled property deed, HOA letters, survey map, bylaws, photos. It felt like I was building a case one PDF at a time. I expected silence for a few days, maybe a week. Instead, my phone rang the next morning. His voice sounded different this time, less calm, more alert. "Did you recently refinance your home?" The question caught me off guard. "Yes, about 2 years ago." Another pause. Papers shuffling. That's what I thought. I sat down slowly. Why does that matter? Because during refinancing, he explained, the title company performs a title search, a deep dive into public records to make sure no one else has a legal claim to your property. If there had been a recorded easement, a public corridor, or any HOA ownership claim, it would have surfaced immediately. It didn't, which meant one thing. There was no recorded easement, no legal transfer, no filed amendment, no public land designation. The dotted line in that photocopied plan, just an idea that never became real. Relief washed over me, fast, powerful, dizzying, but it didn't last, because his next sentence hit harder. If they knew that, and kept moving forward anyway, this gets serious. Serious. The word echoed louder than anything he'd said before. That afternoon, he sent a formal letter to the HOA demanding proof of the recorded easement and ordering them to stop all activity on the property immediately. The clock had officially flipped. For the first time, the pressure wasn't just on me. It was on them. And that's when the second twist arrived. Not in the mail, not an email. In person. I was watering the plants when a car I didn't recognize pulled into the driveway. A man stepped out wearing a suit that looked too formal for the neighborhood. He introduced himself as a representative of the HOA board. His smile was polite. "Practiced. We'd like to resolve this amicably," he said. Amicably. He explained that the trail project was important to the community. That delays were expensive. That conflicts created unnecessary tension. Then he got to the point. The HOA was willing to offer compensation for the land behind my fence. Offer. Compensation. I blinked, trying to process the words. Just days ago, they were insisting the land was public, that I had no claim to it, that I needed to cooperate. Now, they were offering to buy it. The contradiction hung in the air between us. I asked the only question that made sense. If it's public land, why are you offering to pay for it? His smile tightened just slightly. It's simply the fastest solution for everyone involved. Fastest. Not right. Not legal. Fastest. He handed me an envelope and told me to consider the community's best interests. Then he left. I didn't open the envelope right away. I already knew what it meant. This wasn't a misunderstanding anymore. This was strategy. They had expected compliance. Silence. Cooperation. Not documents. Not attorneys. Not resistance. Inside the envelope was a number. A large one. More money than I'd ever seen offered for a strip of backyard land. For a moment, the moral dilemma hit hard. This fight had already taken weeks of stress. Sleepless nights. Awkward conversations with neighbors. Growing tension in the community. And now there was an easy exit sitting in my hands. Take the money. Remove the fence. Let the trail be built. Problem solved. Except it didn't feel solved. It felt bought. And as tempting as the offer looked on paper, one thought refused to leave me alone. If they truly believed the land was public, they wouldn't need to pay for it. That evening, the neighborhood chat lit up again. This time, the tone was different. Someone posted, "Hope the last homeowner cooperates so the project can move forward." Last homeowner. Singular. No names. No accusations. But the message was clear. The pressure wasn't just legal now. It was social. And somewhere in the middle of that noise, my attorney sent a short email that made my heart start racing again. They've responded to my letter. "We need to talk tomorrow." No details. No explanation. Just urgency. And suddenly, the easy exit in the envelope didn't feel so simple anymore. I barely slept that night. The envelope sat on the kitchen table like it was watching me. The number inside it had weight. Not physical weight, but the kind that presses on your thoughts. The kind that whispers how easy it would be to stop fighting. But the attorney's email kept replaying in my mind. "We need to talk tomorrow." When the phone finally rang the next morning, I answered before the first ring finished. They replied, he said. My chest tightened. And they sent documentation. For a split second, my stomach dropped. Documentation meant proof. Proof meant the possibility that everything I believed could collapse in an instant. But his tone shifted. They didn't send proof of an easement. I exhaled slowly, not realizing I'd been holding my breath. They sent something else. Papers rustled on his end of the call. They sent internal HOA meeting minutes. That didn't make sense. Why would they send that? He kept reading. They admitted the easement was never recorded. The room went completely silent. They knew. Yes, he said, and it gets worse. My grip tightened on the phone. According to these notes, the board believed the land should have been designated as a public corridor during the original development, but it never was. So they decided to move forward and resolve ownership later. Resolve ownership later. The words echoed like a confession. They planned the trail knowing the land still belonged to you, he continued. They assumed you would cooperate or accept compensation. The envelope on the table suddenly felt heavier than ever. They hadn't been mistaken. They'd been betting on me giving in. The attorney didn't hesitate. He filed an emergency motion that same day to stop all activity on the property. Within hours, the HOA's survey work halted. The construction plans froze mid-step. The countdown they'd started suddenly stopped ticking. And then came the court date. It arrived faster than I expected. No dramatic months-long build-up. No endless dilas. Just a quiet morning in a courthouse that smelled faintly of old paper and polished floors. The HOA board sat across the room in neat suits and serious expressions. People who had once sent cheerful newsletters now avoided eye contact. My attorney placed the property deed, the survey map, and the refinancing title report neatly on the table. Clear, official, undeniable. Then he placed the HOA's own meeting minutes beside them. Silence filled the room as the judge read. Minutes passed, maybe only a few, but they stretched long enough to feel like hours. Finally, the judge looked up, and everything changed in a single sentence. The court finds no evidence of a recorded easement or public designation. The property belongs to the homeowner. All HOA actions regarding the land must cease immediately. Just like that, weeks of tension collapsed into one moment. The trail project stopped. The fines vanished. The notices became meaningless paper. The orange stakes behind my fence were removed within days. The fight that had consumed my life ended in minutes. But the story didn't end there. Because a week later, a thick envelope arrived in the mail. Not from the HOA, from the city planning office. Inside was a decades-old document I had never seen before. The original neighborhood development proposal. Not the photocopy the HOA sent. The full version. And buried deep in the final pages was a section that changed everything. The proposed walking trail corridor had been rejected by the city during the neighborhood's original approval process. Rejected. Officially. Permanently. The dotted line had never just been forgotten. The neighborhood felt different after the court decision. Not in loud, dramatic ways. No big announcements. No public apologies. Just small changes you could feel if you paid attention. The survey trucks stopped appearing. The HOA newsletters suddenly stopped mentioning the walking trail. And the group chat, once full of excitement, quietly moved on to gardening tips and lost package posts. Like the whole thing had never happened. But for me, it had changed everything. A week after the court ruling, the HOA sent one final letter. Short, careful, polite in a way that felt very different from the earlier notices taped to my door. They confirmed that all fines had been withdrawn and that the project had been indefinitely paused. No admission of wrongdoing. No explanation. Just the quiet closing of a chapter they clearly wanted forgotten. I didn't need an apology. The outcome spoke louder than one. What surprised me most was the shift in the neighbors. Slowly, conversations started happening. Quiet ones. Casual ones. The kind that begin with "I didn't know the full story" or "I heard what really happened." The same people who once celebrated the trail began asking questions about HOA power, property rights, and how decisions were made behind closed doors. The narrative had changed. Not overnight. Not publicly. But steadily. One evening, the neighbor who had warned me that a lot of people really want this stopped by again. This time he didn't stand at the edge of the driveway. He walked all the way to the fence. "I read about the court decision," he said, hands in his pockets again. I guess we all assumed the HOA knew what they were doing. Assumed. That word lingered between us. Because that had been the real story all along. Not fences or trails or orange ribbons in the wind. It was assumptions. The quiet belief that someone else had already checked the details. That the paperwork must exist somewhere. That the system must be right. Until someone looks. The moral dilemma that once kept me awake at night now felt clearer. I had worried about being the difficult neighbor. The obstacle. The person standing in the way of something the community wanted. But standing in the backyard now, listening to the wind move through the mango trees, I realized something simple. Protecting what's yours isn't selfish. It's responsibility. Not just to yourself, but to the truth. Because the final twist of this whole experience wasn't the court victory. It wasn't the rejected city document. It wasn't even the offer in that envelope. It was how close I came to accepting it. How easy it would have been to take the money, remove the fence, and convince myself it wasn't worth the fight. How easily the story could have ended quietly with no one ever knowing what had actually happened. That realization stayed with me longer than the court ruling ever could. Now, mornings feel peaceful again. Coffee tastes normal. The backyard feels like home instead of question mark. The fence stands where it always has, no longer feeling temporary. And every time I look at those trees, I remember the night I opened that drawer and chose to ask one simple question. Is this actually true? That question changed everything. If there's one thing this experience taught me, it's that paperwork matters. Records matter. Asking questions matters. And sometimes the only thing standing between you and losing something important is the decision to look a little closer. So if you've ever received a letter that didn't feel right, if you've ever been told to just cooperate, if you've ever felt that quiet doubt whispering in the back of your mind, don't ignore it. Check the documents. Ask the questions. Stand your ground. Because the moment you assume someone else already did might be the moment you lose more than you realize. And if this story made you think or reminded you how important it is to know your rights, share it with someone who needs to hear it. You never know whose fence might be next.